Your flat can be perfectly safe, perfectly legal, and you can still lose £240,000 because of a single missing signature. That is not a hypothetical. In 2025, the upper tribunal ruled on a building called Center Point House, where a landlord tried to recover £7 million in cladding remediation costs from the leaseholders living there. Split across the block, that worked out to around £240,000 per flat. The tribunal's 93-page decision went in the leaseholder's favor, but only because the specific protections in the Building Safety Act happened to apply to their exact situation. In a separate case, a leaseholder named Mr. Lehner had failed to send back the one form that proves you qualify for protection under that same act. By the letter of the law, that should have been the end of it. His lease should have been treated as non-qualifying, and he should have been fully exposed to whatever bill his landlord decided to send him. He was saved only because his landlord had also failed to follow the correct process for requesting the form in the first place. Two mistakes canceled each other out, and he kept his protection by accident. As the tribunal put it in its own ruling, the complexity of the new statutory provisions is obvious, but it is essential that they be grappled with in any case where liability for a service charge relating to building safety is an issue. Most leaseholders will not get Mr. Lehner's luck. Most leaseholders will make the mistake, and their landlord will not make one back. I've spent this channel documenting how 3 million UK leaseholders are trapped by rising service charges, cladding remediation bills, and a mortgage system that punishes people for owning a flat they didn't build and didn't design. Nearly 9 years after Grenfell, government figures put the number of buildings still needing cladding fixed at over 4,000, with only around a third of them actually remediated. That is the scale of the crisis this legislation was built to manage. But this video is not about the villain. This is about the 5 documents that decide whether you become the next Mr. Lehner, saved by luck, or the next name in a tribunal judgment paying out £250,000 because nobody told you the paperwork existed. Every one of these documents already exists today, right now, for free or for a few pounds. And almost nobody files them, because nobody tells the leaseholders they need to. Here's the date to mark. On the 1st of November 2026, RICS brings in a new second edition standard for how valuers assess cladding risk on residential flats. It changes the criteria for exactly which buildings do and don't need one of the documents on this list, based on height, cladding type, and features like balconies. That is under 4 months away as I record this. If your building has any cladding at all, the paperwork sitting in your inbox right now, or not sitting there because nobody sent it, determines what your mortgage broker tells you after that date. By the end of this video, you will know exactly which 5 documents apply to your flat, exactly how long the law gives you to file each one, and exactly what happens the day after that deadline passes. This isn't a suggestion to speak to a solicitor eventually. 3 of these 5 documents carry hard statutory deadlines measured in weeks, not months, and at least one of them cannot be filed retroactively once the clock runs out. There is no appeal window. There is only the certificate you sent or the one you didn't. Document 1. The Leaseholder Deed of Certificate. If your building is 11 meters tall or 5 stories or more, this is the single most consequential form you will ever complete, and most leaseholders alive today have never heard of it. Under Schedule 8 of the Building Safety Act 2022, your lease starts out presumed to be a qualifying lease, meaning you are shielded from cladding and fire safety remediation costs. But that presumption only survives as long as you can prove it, and the proof is this certificate. It records whether the flat was your main home or one of no more than 3 UK properties you owned in total. As of the 14th of February 2022, a fixed date written into the legislation that never moves, no matter when you actually read this. Once your landlord formally requests the certificate, which they are required to do within 5 days of learning about either a sale or a safety defect, you have 8 weeks to return it, with a further 4-week extension available if you ask for one in writing. Miss both windows, and your lease is treated permanently, as if it never qualified at all. That's the exact mechanism that nearly caught Mr. Lehner. And here's the detail almost every guide skips. The certificate has to be executed as a deed, signed in the presence of an independent witness who is over 18 and who is not your spouse, your civil partner, a family member, or anyone you live with. People fill in every box correctly and still invalidate the entire document because they handed it to their sister to witness over breakfast. The money attached to getting this right scales with your flat's value on that same fixed date. Properties worth under £325,000 in London or £175,000 elsewhere pay nothing at all toward non-cladding remediation. Above that, the cap rises to £15,000 in London or £10,000 elsewhere, climbing to £50,000 for flats worth between 1 and 2 million, and up to £100,000 for anything above that. Cladding removal itself is fully protected regardless of value for any qualifying lease. You do not have to wait to be asked. Download the government's free template today, complete it, and send it to your landlord's correct registered address, ideally by recorded post, so you have proof of the date. Document 2. The Section 42 notice and the 80-year cliff edge sitting under your lease right now. This is the document that costs ordinary leaseholders the most money purely through procrastination, because nothing about it feels urgent until the day it suddenly is. Once your remaining lease term drops to 80 years or fewer, a cost called marriage value is triggered by law, and you are required to hand half of the increase in your flat's value to your freeholder, on top of the standard extension premium you'd pay anyway. The numbers move fast near that threshold. Extending an 85-year lease instead of waiting until it falls to 79 can differ by more than £8,000. And every month you sit below 80 years, that gap keeps widening, because the shorter the lease, the more valuable the marriage value becomes. The document that protects you against this is a Section 42 notice, the formal statutory notice that freezes your valuation date the instant you serve it, even if your lease crosses below 80 years while your solicitor is still processing the paperwork behind the scenes. After, and you are contractually splitting that increase with your freeholder for as long as you own the flat, unless you extend again. Recent reform has also raised the maximum lease extension from 90 years to 990 years and reduced ground rent to a peppercorn on completion, but none of that changes the 80-year rule itself. If your lease is anywhere close to 85 years remaining, this is not a someday task on a list. This is a this week task. If any of this is landing, subscribe now, because the next 3 documents are the ones that let you actually fight back on the bill itself, instead of just paying whatever number lands on your doormat. And I cover exactly this kind of leasehold paperwork every single week on this channel. Document 3. Your written response to a Section 20 notice under Section 20 of the Landlord and Tenant Act 1985. As amended, your freeholder is legally barred from charging you more than £250 toward major works or £100 a year toward a long-term service contract unless they formally consult you first. That consultation lands on your doormat as a notice. First, a notice of intention describing the proposed work, then a notice of estimates once contractor quotes come back, and at each stage, the law gives you 30 days to respond, ask questions, or nominate your own contractor for a competing quote. Here is the part that actually matters to your wallet. If your freeholder skips this process, or gets any stage of it wrong, the law caps what they can legally recover from you at that same £250, no matter how large the real invoice turns out to be. Tribunals have applied this rule strictly for years, going all the way back to a landmark Court of Appeal ruling that closed a loophole landlords had been using to argue their way around it. An honest mistake on the landlord's side is not treated as an excuse, but that protection only crystallizes if you actually respond within the 30-day window and keep a dated written record that you did. Silence does not trigger the cap. A paper trail does. Document 4. Your Section 21 and Section 22 request for the actual service charge accounts. You have a standing legal right to demand a written summary of exactly what you've been charged for, covering the last 12 months of the accounting period, and your landlord must hand it over within 1 month of your request or within 6 months of the accounting year ending, whichever date lands later. If they don't, that is not a customer service failure you can shrug off. It is a criminal offense under Section 25 of the same Act, punishable on conviction by a fine of up to £2,500 and, in some interpretations, up to 6 months' imprisonment. Local authorities have the power to prosecute. If they won't, you can bring a private prosecution yourself. Once you actually have the summary in hand, Section 22 lets you go further still. The right to inspect the underlying invoices, receipts, and contracts behind every single figure for a full 2 months, completely free of charge, with copies available for a reasonable fee. This is the document that turns a vague, unexplained service charge demand into something you can genuinely challenge line by line in front of a tribunal. Most leaseholders never ask. The small number who do are consistently the ones who catch padded invoices, duplicated contractor fees, and management charges that were never properly authorized in the first place. Document 5. Your building's current EWS 1 status. This is the one that decides more than anything else on this list whether you can sell your flat or remortgage it at all. Under the most recent government lender data, an EWS1 form, or its lender-approved equivalent, was required on around 9% of all flat valuations nationally. But break that number down by height and it stops looking small. For buildings of 7 stories and above, that figure jumps to 47% of every single valuation. If your building's assessment comes back rated B2, mainstream lenders will not lend on any flat in that block until remediation is fully complete, and a fresh, passing assessment replaces the old one. That is not a paperwork inconvenience you can push to next quarter. That is your flat becoming functionally unsellable and unmortgageable overnight through no fault of your own. You need to know in writing whether your building currently holds a valid EWS1, exactly what rating it received, and whether the new RICS standard landing on the 1st of November changes what your specific building will be required to produce. If your freeholder is quietly sitting on an out-of-date or entirely missing assessment, that is a fact you want documented and on record before you're halfway through a sale and a buyer's solicitor uncovers it for you at the worst possible moment. Add it up. 5 documents. A deed of certificate worth up to £100,000 in protection, and £0 if your flat falls under the low value threshold. A Section 42. Notice that can save you £8,000 or more purely by beating a deadline that moves closer every single day. A Section 20 response that caps an otherwise uncapped bill at £250. A Section 21 and 22 request that turns your landlord's silence into a criminal offense working in your favor. And an EWS 1 check that tells you the truth about your flat's saleability before a buyer's solicitor tells you first. None of these cost more than a few pounds to file. None of them require a barrister to complete. What they require is knowing they exist and knowing that the clock on at least 2 of them starts the moment a letter from your landlord lands on your doormat, whether you open it that day or 3 weeks later. And this isn't happening in isolation. If you watched my last video, you already know the building safety levy lands on new build flats from the 1st of October 2026, adding thousands of pounds to the cost of a brand new London property before a single leaseholder even moves in. That's the government's attempt to fix the front end of this crisis, forcing developers to pay into remediation up front. These 5 documents are how you protect yourself on the back end in a flat that already exists, with a lease that's already running and a landlord who is under no obligation to explain any of this to you unprompted. The levy and the certificate are 2 sides of the same broken system. One taxes the next generation of buyers before they've signed anything. The other tests whether the current generation of leaseholders can prove on paper that they don't deserve to inherit a bill for a building they didn't build. Here is what connects all 5, and it is the same thing that connects every video on this channel. The Building Safety Act assumes you already know to send your certificate back within 8 weeks of a request you might not even recognize as significant. The Landlord and Tenant Act assumes, unprompted, to ask for your service charge accounts in writing rather than just paying the number on the invoice. RICS assumes your freeholder will voluntarily disclose your building's cladding status before you sign a sale contract, rather than you finding out from a stalled mortgage application. None of these bodies send you a reminder letter. None of them knock on your door. Mr. Lehner survived his own missed deadline only because his landlord happened to miss one too. 3 million leaseholders across England and Wales are not all going to get that same accidental stroke of luck. This system was never built to protect you by default. It protects you only if the paperwork goes out, on time, in writing, correctly witnessed, before the door on each deadline quietly closes behind you. So, start today, not next month. If your building is over 11 meters or 5 stories, download the Deed of Certificate template from gov.uk and complete it now. You do not need to wait for your landlord to ask. If your lease is anywhere near 85 years remaining, call a solicitor about serving a Section 42. Notice this week, not once your lease actually crosses 80 years. And if a Section 20 notice or an unexplained service charge demand has landed on your doormat in the last 12 months, use your Section 21 right today to demand the summary sitting behind it. Tell me in the comments which of these 5 documents you're missing right now. I read every single one, and if enough of you are stuck on the same form, I'll come back with a full line-by-line walkthrough of exactly how to file it correctly. Subscribe if you want that follow-up when it lands, and if you know someone else sitting in a leasehold flat who has never heard of a single one of these 5 documents, send them this video before their landlord's letter arrives instead of mine.